there are 6, 7 speakers. Everybody will take 5 minutes. 5 minutes each. Rajeev, Gowda, 5 minutes. Everybody will take 5 minutes.
Thank you, sir. So I rise to speak in support of the Employees' Compensation Amendment Bill 2016. So when a job seeker goes and looks for a job, he or she is entrusting their lives to the employers. The working conditions matter, and injuries and deaths can happen on the work floor. It's extraordinarily important to ensure that anyone injured is compensated, but even more important, it's important to assure the people who are entering the workforce that they are in a secure environment and that if anything goes wrong, they need to have the information that they can seek compensation, their survivors can seek compensation. We cannot rely on a judicial system alone. We cannot rely on tort law and liability and negligence, and et cetera, et cetera. So this, this particular bill has been originally introduced by the British in 1923 and most recently amended during the UPA era by Sri Mallikarjun Kharge when he was the Minister for Labour. So when the UPA amended this bill, it actually made a number of very, very progressive moves. For example, it aimed to strengthen social security to employees. We were just talking about women. It made the term workman, it replaced that by employee to make it gender neutral, and it ensured that the amount of compensation was also significantly increased from 80,000 to 1.2 lakhs for a death and from 90,000 to 1.4 lakh for permanent disablement. So these are all very, very positive moves, and this bill also has some positive features. For example, it makes it obligatory on the part of the employer to inform the employee of his or her rights to compensation in writing, electronic means, and I'm sure orally as well. So this is all fine, but there are 2-3 issues that I want to raise before you take out ring the bell. So basically the first one is that the threshold that is now applicable in the context of appealing to the High Court. Previously, it used to be 300 rupees. Anything above that sum could be appealed to the High Court. Now that threshold has been increased to 10,000 rupees. So this can actually have a very, very unjust and unfair impact on poorer employees. The amount of compensation is often tied to a person's monthly wage. And if a monthly wage is less than 10,000 rupees, then the compensation amount will also not be that much or more. And as a result, the ability of the employee to challenge the compensation, to challenge the employer's activities will be hampered. And so this is something that you must take into account and find a way to ensure that, and in fact, this bill says that the government can hike this amount at will. We have to protect the poorest of the poor and the people who are vulnerable in employment situations. So I would urge the Minister to please look at this issue in some more detail and make whatever changes need to be made in the rules so that no vulnerable worker is affected. So there are 1 or 2 crucial issues that I want to raise. You know, in general, this is good in terms of incentivizing employers to report what's going right, what's going wrong, etc. But there are 2-3 groups of people who are actually left out. During this demonetization exercise, we were talking about how much of India is employed in the informal sector. We said 45% of GDP is created in the informal sector, 80% of employment is in the informal sector. So how does this act apply to people in the informal sector? Take the case of domestic help. Many of us are fortunate enough to have people who stay with us, work with us for long periods of time. Because they are in informal...
Minute. 1 minute, Raju.
That's fine. Sir.
Yes, yes. Yes, yes. I know, sir. तपन जी बैठिए. ठीक, तपन जी बैठिए. सुन रहे हैं.
Sir, as the initiator of the discussion, 5 minutes is a little too little also. But let me try and keep it short. I also prepared for half an hour, but I'm doing some speed speaking. Anyway, sir. So the other issues. Recently, we've seen some tragedies in the context of manual scavenging. People who go in there to try and clean up clogged sewage drains and die because of the noxious fumes. What do we do in those cases? We say ex gratia payment, 1 lakh, 2 lakh, 3 lakhs. We will try and do something else for their families, and we move on. Life is very cheap in India, and that is something that we must militate against, because every human is worth something significant, and we have to ensure that we, as any employer who goes out there and puts an employee in danger, must take care of not only that employee, but and whatever injuries and death might occur, but also the damage to, if that is the only person who is a wage earner in that family. That is something to be concerned about. So, this is actually something that applies across the board. Railway accidents, any kind of industrial accident, everyone gives an ex gratia payment, life is cheap, 2-3 lakhs, move on. And that is a terrible incentive to employers to not take care of employees. But more than anything else, sir, this bill and the term injury itself applies to injuries which are visible. Someone losing their hand, someone losing their leg, a limb, something like that. But if you look at the workplace today, people are exposed to substances which will, whose impact will happen much, much later in life. A coal miner will work in hazardous conditions, inhale coal dust, and 40 years later, after the person is retired, that coal miner will contract cancer or something like that. Only in a few cases can, for example, asbestos, you have a signature disease called mesothelioma. You can say that this activity resulted in that outcome. But in most other cases, the employer goes scot-free. I would urge the minister to pay attention to these kinds of long-tail risks. When someone is exposed to a risk in the workplace, the legal system also has to respond. You cannot say the statute of limitations, time barred, because the employment took place 40 years ago and the illness occurred now. We have to pay attention to the epidemiology of these kinds of activities, to the toxicology of these kinds of activities, and ensure that some poor employee who gave the best part of his or her life to that particular job is not hurt going forward. So these are not points that are there in this bill. And I would urge the minister to find ways in the rules to ensure that these very practical and humane considerations are included. And with that, I would commend the bill for passage. This is part of the larger agenda of ensuring that anyone who is poor and vulnerable is protected. And in that sense, this is a worthy bill for passage. I commend it to the House for
Dhanyawad,
support. Thank you.
Naresh Agrawal ji.